Hello, welcome to my video talking about the defences of consent and self-defence in criminal law. So I've already looked at some of the other defences, duress and necessity, in another video, and I also talked about the mental capacity defences, so insanity, automatism and intoxication. So the last set of defences to look at have some really interesting cases which should make revision a lot easier. Consent, calling it a defence is actually a bit misleading because it's not really properly a defence. Instead, what it does is it means that any force applied is lawful force rather than unlawful force. So actually, rather than being a defence, it simply invalidates the offence in the first place. So a couple of things. Firstly, let's start right at the top. Consent can't be used for murder, and it's actually limited when it comes to serious injury, as we'll see in a sec. When it actually comes to consent though, it must be real, it must be given voluntarily, and it must be valid, so based on a sound understanding. So what does this actually sort of mean? What does this exclude? So if the victim is duped into giving their consent, that is not real, true, valid consent, as we saw in Tabassum, where the women thought they were consenting to breast examinations for medical reasons, so they weren't giving true, real, valid consent. It also can't be out of just fear. So Oleg Borgia told us very clearly that consent to sex is not just submission. She was scared, and simply submitting to him through fear of further violence did not equal consent. And it must be more than just consenting to general risks. So in the case of Dijkab, we talked about the fact that they were consenting to general risks that come with having unprotected sex, but not to specific serious harm, such as contracting and becoming HIV positive. It might work if it's minor harm. So in Golding, we were looking at cases of herpes, and that is more likely to be a sort of general risk associated with having unprotected sex. So you could possibly consent to having that inflicted upon you by not using protection. Consent, however, doesn't have to be expressly given every time. There are situations where the law recognises that it's implied, so it kind of goes without saying. So social touching is one of those categories. So, a tap on the shoulder, excuse me, or accidentally sort of jostling someone as you're getting off a busy train or bus, or getting into a packed lift. The case, however, of Attorney General's reference number 6 of 1980 said that the law is going to stop short at allowing us to consent to fighting in the streets. For public policy, we can't simply allow that. So even if you both agree to fight, any injury sustained you can still be charged with. You can also have implied consent when it comes to horseplay. So this is essentially people messing around, playing practical jokes on each other, and usually between friends there's kind of an understanding that we consent to some harm. So in Jones, they were talking about that, school kids in the playground, they probably consent to a bit of joking and getting knocked around. Even the boys were being thrown in the air, even though they were actually injured, which is obviously not something they consent to. Generally speaking, it's the sort of thing that tends to happen. And this even went one step further in Aitken, where they were doing sort of hazing rituals when joining the RAF. And they said that, this is something that the defendants believed they had the victim's consent to set them on fire, because they believed they had it because it was a sort of long-standing tradition that a lot of the fellow armed forces members had done. So once you understand the kind of basics, it can be expressly given, but it can be implied, but it has to be real and true and valid. What can you actually consent to? So the law is quite clear that we can consent to quite minor harm on our own. And for this, we're really talking kind of assault or battery. So application of unlawful force or kind of touching, that's acceptable if we consent to it. So in Donovan, the defendant had spanked the victim. That had led to very, very sort of minor injuries, essentially just battery, slight bruising. Now in Slingsby, the victim actually ended up dying from her injuries, and the defendant was charged with unlawful act of manslaughter. But if you think about what they'd intended, he hadn't intended to kill, he just intended to apply force. But that force wasn't unlawful because she'd consented to it. So even though they died, there was no battery to construct the manslaughter out of, because that force was consented to. There was no application of unlawful force. If it gets more serious than that, then that's where the problems begin, because now people are actually getting hurt and may require medical treatment. So this is where the court has to carefully balance our individual liberties, our freedoms to do what we want with our own bodies. We have to balance those with public protection and deterring people from causing serious harm. So you can consent to serious harm, but only really for court-recognised exceptions. And there are a number of court-recognised exceptions within this that are really important. So, for example, properly conducted games and sports, you could end up with a serious injury while boxing, for example. Lawful chastisement or correction, so that means smacking children. Reasonable surgical interference, so medical treatment, things like that. So there are some that are allowed. So, for example, in the case of Barnes, his leg was broken during a tackle, a sliding tackle, but that's one of the potential risks of playing football. So as long as the sport is conducted within the rules of the game, it would have to be very, very, very extreme for a person to be charged. So, you know, if someone goes up and stabs someone during a football match, that's clearly not accepted and unexpected. Medical treatment, we clearly need to have this defense of consent, because if you think of like even a minor surgery, it's cutting someone open, so that's definitely wounding. And of course it's definitely intentional, the doctor's doing it on purpose, but to help you, so we need to have that consent there. Tattooing, piercing, the case of Wilson, very infamous, tells us that those sorts of things are lawful, though they may fall afoul of licensing laws if you just go around tattooing people, and etc. So this is certainly not a closed category, and the courts would consider any fresh new precedent that comes its way. But what we're basically saying is the courts seem to think that the activity seems to need a social usefulness, a utility to society. So things that they've excluded are sexual pleasure. So we have seen this in Donovan and Slingsby, where harm is applied for sexual pleasure, and that is lawful, but we're talking minor harm. So the defendants in Brown and Emmett, for example, were doing very extreme practices for sexual pleasure. So those couldn't be justified because they felt there was no sexual activity to that level would have a benefit or justification in society. So whether that's fair, that the individuals did all consent, the courts say we're going to have to protect people for their own good and set a moral standard. Extreme body modification as well also seems to have caused an issue. So the case of R versus BM involved a person, a tattoo artist, doing very extreme body modification, such as removing earlobes and splitting tongues. Those forms go far beyond tattooing, piercing, and again the court said they didn't feel like there was much of a benefit to allow this to happening. And they also questioned about whether these sorts of things should be taking place without the sort of normal reassurances and safety standards that a surgery and a surgeon would have. So that's consent. We've also got self-defense. So self-defense is essentially where we protect ourselves and others from harm. And what I've just done is split it into a few important questions. So one of the key questions when it comes to self-defense is what is the level of harm that can be used? So if someone is going to attack you or your property or a loved one, exactly what can you do? How far can you go? And the rules have been changed quite a lot here. So we have the Criminal Justice and Immigration Act 2008. Says that the level of force that's allowed is the force that the defendant believed was necessary in the moment. And that's really crucial, because what happens is the law is saying that we have to cut these people some slack and recognise that in the heat of the moment, that person may not be able to rationally weigh up, well, this is what they're going to do to me. This is an appropriate and reasonable and proportionate response. So most of us just don't have that thought process. When someone scary is coming towards us, we just think and react. And the court said, what did the defendant honestly and instinctively think and do at the time? So that the stance of the law is that if a person is acting instinctively, that is probably a suggestion that it's a reasonable course of action, because we don't have time to think, oh, I'm really going to go here, or oh, is this enough? So that person's initial response is probably quite an appropriate response in response to the threat. However, you can't defend yourself after the threat is gone. The moment it becomes sort of revenge or hunting down or things like that, we lose the defence of self-defence, and that's what happened in the case of Hussein. When you chase people out of the house, the threat's gone, and that's no longer self-defence. What if the defendant made a mistake about the danger? So they made a mistake about the situation that was going on, and that's what happened in Gladstone Williams. So he misread the situation and thought someone was being attacked when it was actually a police officer trying to arrest someone. Again, the Criminal Justice and Immigration Act has kind of solidified the rules that came from Gladstone Williams. And again, we're just going back to the question, what did the defendant genuinely believe? So the jury would have to, of course, decide if what they're saying is the truth. But what did they genuinely believe and understand the situation to be? Even if that's a bit of an unreasonable thing to think. So in Gladstone Williams, he genuinely believed that the person was attacking the other. So he acted in response to that, and that's acceptable. Exception is if it's because they were drunk or on drugs. So as we talked about in the defence of intoxication, the law is not really willing to tolerate mistakes, especially about the amount of force if you're drunk or on drugs. So if you're under the influence, you may not necessarily be able to understand the threat. You might think that someone is being more aggressive to you than they are, for example, and you might therefore overreact, and you're responsible. If you are that intoxicated, if you put yourself in that position, then you're reckless as to the amount of force that you're going to use. Finally, there are special rules for householders. So what if you are defending your home at the time? The Crime and Courts Act 2013 is quite a recent update to this law. And essentially, it seems to allow more force to be used as a response. So force is deemed as reasonable unless it's grossly proportionate. So really, the force would fall into one of two categories. Is it grossly proportionate? That's the question to ask yourself. Do you feel that in response to what was happening, it was grossly proportionate? If your answer is yes, then they can't use the defence of self-defence. However, if your answer is, well, I think they overreacted, but I don't think it's grossly disproportionate, then it's still deemed as reasonable. So anything that's not grossly disproportionate seems to be acceptable, even if it is a bit over the top. And again, that's because most of us would act in the heat of the moment. Protecting our home is very important to us, so it can be allowed. If you believe that the victim was a trespasser, then you can use force as long as it's not grossly disproportionate. And this was demonstrated in the case of Collins versus the Secretary of State for Justice. So this is a slightly different case of Collins, nothing to do with ladders. So in the case of Collins, there was an intruder, Collins, and the homeowner had essentially grabbed him and held him in a stranglehold, and during that time he lost consciousness and the oxygen supply was cut off to his brain, and he was left with paralysis. The CPS decided not to bring a prosecution. And again, if you look at this, was that force grossly disproportionate? It may have been more than necessary. It might have been quite aggressive, but the CPS didn't think it would pass the grossly disproportionate test enough to even put before a jury. They felt that a jury would think that was a not grossly disproportionate response. So hopefully that makes the rules clear. Thanks for watching.